Morning, good morning. Now, notification also issued for the appointment of direct district judges from advocates, and you should be alert and cute because this online submission of application gives some practical problems. Therefore, don't hesitate to register your candidature in advance so that you can come across any practical difficulties due to online filing. I hope you understand. Now, today, two cases I am going to discuss. One, Om Prakash Sahani versus Jai Shankar Chowdhury, AR 2023, Supreme Court 2202. This they say at the time of suspending sentence, court must see that prima facie there is possibility of acquittal. Therefore, they have given some discussion and guidelines how to deal with suspension of sentence. If absolutely there is possibility of prima facie acquittal, you can grant suspension of sentence. This is what and they have said because he was on bail is not the ground for suspending the sentence. That was they say. But however, they say it will be a travesty of justice to keep a person in jail for a period of 5 or 6 years for an offence which is ultimately found to have been committed by him. Is not correct. Can the court ever compensate for incarceration? Therefore, this is what they say. See, we have admitted your appeal because we think you are prima facie case, but unfortunately we have no time to hear your appeal for quite a few. Therefore, until we hear appeal, you must remain in jail, even though you may be innocent. Then, if that would be the version of the court, the Supreme Court says it will not be fair better. Therefore, they say if prima facie the case presented by the prosecution accepted by the trial court can said to be a case in which ultimately convict stands for chance of acquittal. They say that is what said. They say on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. So it means there should not be any reappreciation of evidence. This is what they say. Okay, for that purpose that is over. Next question, next judgment is most important for examination purpose of judicial magistrate and also district judges. See, number one, this is this judgment AR 2023, Supreme Court 220, Ravinder Singh versus State Government of NCT Delhi. Here, actually, what happened, you have to understand what is imprisonment for life. Imprisonment for life means what? They say imprisonment for life means the whole term of life. Then in some of sections they say imprisonment of maybe 20 years. In some provisions they say imprisonment may be minimum 14 years. This is what different versions of the IPC. See, they say chapter 3 deals with Indian Penal Code deals with the imprisonment for life means imprisonment for life. This is what they say. Then they say under section 55, in every case in which sentence of imprisonment for life shall have been passed, the appropriate government may, without consideration, commute the punishment for imprisonment, either discretion for a time not exceeding 14 years. That is, they say, for commutation. Then again, and section 57 says IPC, in calculating fraction of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. So these three things you should do. One, they say it is imprisonment for life. Then they say you may commute for not exceeding 14 years. Then they say fraction will be for 20 years. Why this difference? You should understand why these three differences are there. So imprisonment for life is there. The court cannot, the Supreme Court has said the district court have no power to categorize. They say it is High Court or Supreme Court have power upon proper application of it to take recourse to special category sentencing depending upon nature of offence and its gravity. Mere affirmation of all exercise of power by was not conferred, does not qualify as independent exercise by the High Court. They say, with regard to special category sentencing to life imprisonment in excess of 14 years, by fixing lengthier term would be available to the High Court and Supreme Court, even in cases where the maximum punishment permission law and duly imposed is life imprisonment for nothing further. However, excess of such power must be restricted to grave cases, where allowing the convict sentence imprisonment life to seek release after parole would tantamount to trivializing very punishment imposed on such convicts. What all are these source? This judgment seems to be very serious. Therefore, they do not want him to set at liberty even after completion of 20 years. Then there is another things they may again come for 432, government remissions, commutation, all are there. See why these 20 years fraction was dealt by Indian Penal Code was because 511 attempt to commit any offence is punishable under 511. 511 says if the main offence which was attempted have got a punishment, then half of the punishment may be the maximum punishment for attempt for that main offence. I think you understand. Suppose 326 imprisonment for life. 326 imprisonment for life, 326 511. Then question arises how to fraction that half of the sentence. Only for that purpose, the Indian Penal Code says you have to calculate 20 years. So that is most important. Suppose 307 means 307 itself has got self-punishment class. For other cases, 406 or even you say 409. 409 also contains imprisonment for life. If suppose there was an attempt to commit 409, then you will be considered for maximum punishment of 10 years because of the fraction of 20 years is applied here. Therefore, kindly understand the judgment, go through the judgment deeply, what the Supreme Court intend to say, whether that judgment is about to be revisited, because multi number of judgment, the POCSO court judgments imposing sentence even after 20 years. That's what Supreme Court says. That is not power of that is not power of this additional courts or district courts. They will say by additional session judge that was not conferred. This is what they say. They say that was, they say there are 6 and 10. Here there are 6 and 10. 6 says However, the district court has gave a rider that the appellant should not be given clemency of state until he spent 20 years in jail. This is what they say. They say that is not power of the additional. Clemency means remission, admonition. This is what they say. They say it was clearly not within the domain of land additional section to impose a restriction that the term of the appellant life imprisonment should be for at least 20 years. That's power only exercised by the High Court or by Supreme Court. This is what they say. Finally, what they say, only remission will be after completion of 20 years. That's what they say. But however, the judgment of the additional court was accepted. Kindly go through the judgment. The climate is disturbing my mind. That's why I am not in a better position to discuss with you deeply, even though I prepared from the early morning. Best wishes.